am Logie Govender from Old Mutual Corporate Consulting, and I welcome you to the ISASA Retirement Webinar. Jothi Chirkoot is a Senior Legal Advisor at Old Mutual Personal Finance. Jothi will discuss the various components of estate planning that members of the ISASA Pension and Provident Fund need to be aware of.
Today, I will be sharing with you a presentation about a very dynamic aspect of financial planning. This is estate planning. Through the presentation, reference will be made to the estate planner or the planner. This would be the member of the ISASA Pension or Provident Fund who requires a will or an estate plan and to whom the suggestions and recommendations are directed to. The question is often asked, why estate planning? And the answer is, because life happens. As you can see from the slide, there are various events that take place in a person's lifetime. Each of these events has a financial impact on the person's life, be it marriage, a divorce, retirement, and careful and professional planning needs to be given. There is a misconception that estate planning is about the making of a last will and testament, or it's an exercise about savings on estate duty. These are but only a part of the estate planning process. In fact, estate planning is about preserving, growing, and protecting one's assets. It is also about ensuring that these assets are distributed according to the planner's wishes on the death of the planner. A one-size-fits-all type of plan does not work because every planner has a unique set of circumstances and the plan is built around the planner's circumstances. The plan is also as flexible as the planner wants it to be. It is not cast in stone and may be amended regularly or whenever the planner experiences a life-changing event in his life. An estate plan should be professionally compiled, and the estate planner should ensure that he brings on board persons with the relevant knowledge and skills to give him sound and proper advice. We recommend that an attorney or a fiduciary specialist or a legal advisor, together with an accountant or an auditor, as well as the planner's financial advisor, is brought on board, his or her spouse, or a family member, but this is entirely his or her choice. There are various aims and objectives of estate planning. I have highlighted a few, but this list is by no means exhaustive. It is important to achieve efficient deceased estate administration in order to ensure that the deceased estate, after the planner has passed, is wound up smoothly. There's much that can be done during the lifetime of the estate planner. For example, he should make sure that he has a will in place, an efficient executor has been nominated, provisions for minor children for the protection of their inheritance, and also, very importantly, make sure that relevant documentation are collated and it is handed over to the executor when the time arrives by a person, either family member or a friend who has been entrusted with this task. It is also important to appoint heirs of choice and distribute assets according to the planner's wishes. This can be done through the will and by nominating beneficiaries on all investment policies or life policies. An important part of the estate planning process is a liquidity analysis to determine how much of cash will be required by the executor of the estate. Cash is needed in the estate for the payment of taxes. There will be income tax due if the planner was a pensioner and received annuity or was working and received an income. So from the 1st of March, the year that the person dies, to the date of death, there will be income tax payable. Furthermore, there is potential capital gains tax as well as estate duty that would become payable, and cash will be needed for this. The deceased person may have had unfinished business in terms of settlement of liabilities. For example, a bond, car repayments, or just loans or credit facilities which have not been secured. The executor needs to make sure all of this is settled. Then there are estate expenses which need to be paid. For example, master's fees, the executive fees, conveyancing fees, if there's a valuator appointed to value the property, the valuation fees, as well as deathbed expenses. The executor may approach beneficiaries to pay in the deficit if there's insufficient cash, but the beneficiaries are not compelled to pay. If they choose not to pay, then the executor has to sell assets in the estate to create the liquidity to the detriment of beneficiaries. A very important part of estate planning would be to establish how much of capital will be required for dependents and to protect minor beneficiaries or beneficiaries with special needs. The capital would be utilized to provide the minor children or the beneficiaries with special needs with income for living expenses or capital for capital expenses such as tertiary education or perhaps the purchase of a new car from time to time or a new home. But some important considerations here is how to protect the proceeds or the inheritance of a minor child or a beneficiary with special needs. A discussion regarding the creation of a testamentary trust would be necessary to consider whether the trustees should control the inheritance or should the inheritance be handed over to a legal guardian or a curator to be dealt with on behalf of the child. Minimizing the impact of taxes on the estate is important, and during the estate planning process, a good financial advisor will be able to point out to the planner the various tax concessions available to the planner. All taxes have concessions. For example, the donation tax exemption of 100,000 Rand, which amount may be invested in another person's name, perhaps a child or in the name of a trust. This would benefit the child or the trust, but also help the planner to have his estate reduced over a period of time. Capital gains tax can also be reduced by ensuring that the planner keeps record and proof of all acquisition costs of assets that he or she purchases, as well as improvement costs. This can help reduce the capital gain and therefore the capital gains tax. Furthermore, there are certain investments which has a more favorable income tax rate than the actual planner himself. It would be important to consider investing in those policies which have a better income tax rate. To provide for future growth outside the planner's estate is another aspect that is important to consider. There may be a need for the creation of an inter vivos trust, where assets that are transferred into the trust will not form part of the estate of the planner. Whilst there are many benefits of having assets grow in a trust, such as the protection of these assets from creditors or protecting it for the benefit of a minor child or a person with special needs, trusts are quite a complex estate planning tool. And it is really important that a thorough, proper analysis is done to make sure that this is what the estate planner really wants and he or she understands exactly how the trust works, whether his or her objectives will be met, as well as the tax implications and the costs associated with a trust. is fully understood. If an estate planner is a business owner, the business interest needs to be dealt with in the estate plan. A business needs protection just as much as a person's personal estate. The planner needs to consider a business succession plan, and this can be done through a will as an inheritance to a beneficiary, or if the planner wishes to sell his business interest at death, disability, or retirement, then perhaps the possibility of a buy and sell arrangement should be considered. The business also needs to be protected from the loss of its key employees as a result of death or disability of the key employee. So if there is a key person policy on the life of a key employee, the proceeds of the policy would pay out to the business, who would then receive those proceeds and utilize those proceeds to protect itself against any financial strain. Another aspect of financial planning is to provide for clients and families' unique set of circumstances, and provision for this can be made in a will. For legitimate reasons, a member may wish for their estate to be distributed to persons other than families. Perhaps they have a permanent partner whom they live with. If they do not have a will, that partner will not receive any inheritance. To take into account assets that are offshore is also part of the estate plan exercise. If a South African resident has assets offshore, an offshore will in the country where the asset is situated may become necessary to have drawn up. There are benefits to having separate wills. If there is only one South African will, the South African executor would have to apply to the foreign courts for consent or recognition to be able to deal with the assets in the foreign country. This could take time, and also language could become a challenge, as well as the foreign legislation. If there is a foreign will which deals with assets separately from the assets in South Africa, both the estates can be wound up simultaneously. And should there be a delay in one of the estates, it would not negatively impact on the winding up of the estate in the other country. It is advisable to have a discussion with a specialist in this area in order to understand the reasoning for their suggestion as to whether there really should be one worldwide will or separate wills. Furthermore, there are tax implications associated with assets that are held overseas, so this would be very crucial to discuss with the specialist. More and more people nowadays prefer to have a living will. A living will represents a patient's wish at a time when the patient is no longer able to express a view about refusing medical treatment. So, for example, if the patient is on life support and it is their wish that they do not continue on this life support machine, the living will can be given effect to. It is an important part of estate planning to minimize costs on the part of the planner. And remember, the planner is the member of the ISASA Pension or Provident Fund. If the planner or the member has various investments, the possibility of consolidating those investments would result in a cost savings. So this needs to be looked into, as well as if the member or the estate planner is investing too much into one type of investment to the detriment of neglecting another financial need area. This needs to be readjusted and could also be a savings on costs. Reviewing a plan annually is an excellent way to keep updated with revamped products, which probably offer more benefits at the same cost or even less. And those planners or members who have a large estate may even warrant a request to negotiate on executive fees. Very importantly is that a plan must be practical, must be legal, and efficient. If a member has a primary residence which they wish to leave to all their children equally, if they have 3 children, on the planner's death or the member's death, the first child might want to live in that house. The second child might want to have the house rented out. And the third child might want to have the house sold. So this could lead to a conflict amongst the family members. These are things that need to be discussed with the financial advisor and the legal advisor to look at various ways as to distributing the assets on the planner's or the member's death. A will is one of the most important parts of an estate plan, and it should be reviewed regularly. Whenever a life-changing event occurs, such as death, a birth of a new child, marriage, a divorce, to ensure that the will complies with all legal requirements, it is really important that a will's consultant or a will's specialist is asked to draft the will. There are various legal requirements that need to be met in order to ensure that a will is valid. The testator or testatrix, the person who signs the will, must be 16 years or older, and a witness must be 14 years or older. Both must be of sound mind and be able to appreciate their acts. A witness does not have to read the content of the will. All the witness does is to ensure that the person who is signing the will is doing so of free will and voluntarily. A witness should not be a person or any person mentioned in the will, nor their spouses. In some cases where the testator or testatrix is unable to sign a will, their thumbprint may be used, or a cross or a scratch, but this needs to be before a commissioner of oaths. And the commissioner of oaths needs to also append his signature below that of the testator or testatrix. Furthermore, the commissioner is required to attach a commissioner certificate at the end of the will to confirm that this will was made freely and voluntarily, and that the testator or testatrix was of sound mind. In terms of an overview of how an intestate estate will be wound up in the event that a person dies without a will, is through the laws of intestate succession. These laws will dictate how the distributable estate will be devolved upon the family members. If there is a surviving spouse without any descendants, the surviving spouse will receive the inheritance. If there is a surviving spouse as well as descendants, then both the surviving spouse as well as the descendants will receive an inheritance. Unless, of course, the estate is less than 250,000 rands, in which case the surviving spouse will receive everything. If there is no surviving spouse and there are no descendants, we then move up the family tree to the parents of the deceased person. Each parent is entitled to 50% of the deceased estate. Should there be a deceased parent, that deceased parent's descendants will receive the 50% that he or she was entitled to. With regard to the nomination of an executor. Much thought must be placed here, especially if the estate is above 250,000 rands. An executor should ideally be a person who has the necessary skills and knowledge to wind up an estate, because winding up an estate is a process. And if left to a person who does not have the necessary skills to wind up the estate, this could lead to a delay in the winding up of the estate due to queries raised by the Master of the High Court not being efficiently dealt with, or even generally in terms of accounting to the Master of the High Court in the prescribed format. All of these would lead to the delay in finalizing the estate to the detriment of the beneficiaries. In any event, the Master of the High Court, if he or she becomes aware that the executor does not have the necessary skills and knowledge to wind up the estate, they may request that the executor provide a certificate from a professional executor confirming that they provided guidance to the executor. So we are saying, appoint the professional executor yourself rather than leaving it to another person to do so. Professional executors are attorneys, accountants, or trust companies. One's marital regime plays a very important role in the entire estate planning process due to the proprietary consequences that flow from the different types of marital regimes. There are essentially three types of marital regimes. The first being a marriage in community of property, where the assets and liabilities of the joint estate are owned equally by each spouse and are shared equally by each spouse. A marriage out of community of property, where each spouse owns their own estate in its entirety and neither one of them has a claim over the other's estate. The third type of marriage is a marriage out of community of property, which includes the accrual regime. This marriage is a mild blend on the two earlier marriages that I just spoke about, but actually not quite, in the sense that each spouse owns their own separate estates and runs these estates independently from the other, and their estates are only brought together at death or divorce, when a calculation has to be done to determine the accrual in each of the estates during the subsistence of the marriage. The spouse's estate, which has a higher accrual, has to pay an amount over to the spouse's estate that has the smaller accrual in order to equalize and balance the value of both the estates. With regard to having a life partner, this type of relationship is not recognized in terms of the Matrimonial Property Act, and there is absolutely no proprietary consequences that flow from this relationship. For those who have maintenance obligations, it is important to take note that these obligations do not fall away if the member or the planner dies or becomes disabled. Those obligations still need to be met. So provisions for these obligations must be met when the planner is no longer actively able to meet those obligations. These provisions can take various forms, obviously depending on the type of assets owned by the planner. Usually it is through life or investment policies. Such situations may also warrant the consideration of having a testamentary trust created, where the capital can be held on behalf of the minor or the ex-spouse, and the trustees take control to meet those maintenance obligations. Alternatively, if the planner is comfortable with the ex-spouse or the minor child's guardian or curator to receive the full proceeds on behalf of the child for the child's benefit. With regard to domestic partnerships in South Africa, these relationships are not recognized in terms of legislation. So where do domestic partners or partners in a permanent relationship stand in relation to propriety consequences or the legislation, or generally in terms of each other's financial affairs? Each legislation has to be looked at individually. In terms of the Income Tax Act, a spouse includes a person who is a partner of the taxpayer in a same-sex or a heterosexual relationship which the Commissioner is satisfied is intended to be permanent. Factors that indicate a relationship is permanent would be joint ownership of assets, partners living together in the same residence, having children together, the time period of the relationship, being dependents or beneficiaries of the same pension fund, medical scheme, or insurance schemes. All of these are indicators that there is a permanent relationship. And this would result in the partner being regarded as a spouse. So the tax concessions that a spouse normally receives in terms of the Income Tax Act would be extended to a permanent partner. For example, donations between spouses do not attract donation tax. There's no capital gains tax between spouses, nor estate duty. So in this way, permanent partners would benefit. However, if we look at other legislations, like, for example, the Intestate Laws of Succession Act and the Maintenance of Surviving Spouses Act, these acts do not recognize permanent partners as spouses. So in terms of the Intestate Laws of Succession Act, a permanent partner cannot inherit if the deceased partner died without a will. After establishing how much of liquidity is required by the estate planner and making the necessary provision for this, it is important to leave the balance of the proceeds from policies directly to beneficiaries. In other words, making sure that there are beneficiaries nominated on all the policies. The benefits of this is that the proceeds will pay out directly to the beneficiaries, bypassing the estate. So if the beneficiaries are in need of capital soon after the death of the planner or the member, these proceeds will benefit them. However, the executor will still have to account for these policies in the estate. But because he doesn't or she does not have to deal with these proceeds in the estate, the executor cannot claim a fee on policies where they have beneficiaries nominated. So there would be a savings on executive fees. As a parting shot, I would like to say, don't be a statistic. Make the time to put an estate plan and a will together, define your wishes, and remember to review and update regularly. Thank you.